Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, folks, and welcome to today's Mailers Hub webinar. Today we're going to be talking about the state of state privacy laws. We're going to wait another minute or so until folks get in their seats. We have some people still signing in and joining the group, so as soon as we have the crowd all in place, we'll get started. So just stay sitting there for a second, and we'll be back to you shortly. Thanks. Okay, good afternoon again, folks. And as I said, welcome to today's Mailers Hub webinar. We're talking about the state of state privacy laws today. And we'll be having presentations from David Swetnam-Berland and Stacy Stitham from Brann and Isaacson, the law firm that we're very proud to be affiliated with. And before they start, I want to give you a little bit of a background on our two speakers today. Both David and Stacy are partners with Brann and Isaacson, and the firm represents business clients including over a dozen of the nation's 100 largest internet retailers and business false claim intellectual property privacy and tax litigation. David appears regularly in federal and state trials and appellate courts nationwide, as well as before state and federal administrative agencies. David also advises clients on compliance issues in the areas of data privacy and security, and state and local tax. He's a member of the Maine, California, and Oregon bars. Stacy, of course, also advises folks on things like compliance issues in the areas of data privacy and security, as well as intellectual property. And she is a member of the Massachusetts and Maine bars. So we have two very qualified and experienced speakers with us today. So before any further ado, go ahead, David, Stacy, thank you, and welcome.
Thank you, Leo. This is David Swetnam-Berland, and Stacy and I are delighted to have been given this opportunity to talk to you about the emerging state of privacy laws in the states around the country in the absence of overriding federal legislation, which we'll talk about the prospects for that at the end of the presentation. I should say up front that although we're both well versed in this area of the law, that's not to say we have a lot of answers to a lot of burning questions that many folks have, because many of these statutes are newly adopted. Only California and Nevada have statutes that have been in effect for any period of time. Other state statutes won't go into effect for a year or two. And so that means there is not a body of interpretation at the state level for many of these statutes. And so what we can do is give you a roadmap to how things appear to be progressing in this field and a sense of the issues that you can be paying attention to now so that you'll be prepared to adjust to an unfortunately complex, but I think manageable privacy, the privacy challenges that come from the application of these state laws. So if I could have the next slide, please. So I'm going to start with just a general overview. And a lot of this is going to be informed by, as I said, by the California statute, which is the one that has been in effect for about a year, although it is unfortunately about to change somewhat. But California has set the template for state privacy laws across the country. The laws that have been recently passed often are modeled on or make tweaks to the California model. So what does that mean? The key thing is what is being protected? Whose privacy is being protected? At the beginning, while these statutes speak in terms of consumer privacy, that term is defined very broadly to mean any natural person who's a resident of the state. And so whether you're in California, Colorado, or Virginia, typically when you see the word consumer, that means human being in essence, whether that person has had a business relationship with you or a company that you do provide services to or work with. The scope of the statute is broad with respect to any individual and information that might be gathered about that person. And the type of information is also very broadly defined as to what constitutes personally identifying information. Under the California definition, for example, that would include any information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or even that consumer's household. And so much of the concern generated by these statutes relates to the extreme breadth of that definition of personally identifying information, particularly when it comes to inferential links. At what point does a business have an obligation to assume that someone could take certain information and deduce the identity of a person, even if that information was not directly related to a known individual in the database or other repository? Also at a broad level, there's the rights and protections that are being provided under US state laws are a little bit different from those that are addressed by the GDPR in the European Union, and some of you may have some familiarity with that context. First, they tend to be focusing on notice, providing notice to consumers of what's being collected, for what reason, and from what individuals. And those notices are generally going to need to be provided online in a formal privacy policy with links from pretty much every page of your website. And if you or your business or businesses you work with are engaged in distributing print materials, as obviously many, if not all of you are, then there may be an emerging need to have at least a reference to an online privacy policy in printed materials, if not a printed version of the policy. I think the key thing behind all of these statutes, and the key thing from the point of view of any business trying to get their hands around these issues, is data security. And I mean, to be honest, that would be true with or without these statutes, given the existing data breach laws and the significance of data breaches. But when it comes to personally identifying information, these statutes are requiring encrypted, securely stored information, encrypted at all points in transmission, and deliberate and recorded data breach planning and prevention by businesses that handle personal information either for themselves or on behalf of their clients, business clients. Finally, what rights are accorded to individuals by these statutes? It varies from state to state, but generally falls into the following categories. The right to know, that is the right to ask a business, what personal information do you have on me or my household? The right to correct, meaning the right to say, now that I've seen my personal information, you have certain details about me incorrect in your records and those should be corrected. The right to delete, also known as the right to be forgotten, that is the right to as the term suggests, have certain personal information deleted from records. And there is play in all of these statutes under that right for a business to maintain certain personal information, even when faced with a delete request, that's necessary to perform the business function and to maintain the business relationship with the consumer. And last of all, the right to opt out, which can range from opting out of the collection of any personal information or retention, opting out of print materials, opting out of electronic communications, opting out of cookies. Again, the precise nature of the opt-out right is defined by state statute. And if I could have the next slide, and I'll turn it over to Stacy for a moment.
Thanks, Dave. Good afternoon, folks, or I guess depending on where in the country you are, good morning. This is Stacy speaking for the next few minutes here. And I'm going to talk a little bit about sort of who's regulated under the law that the overview that Dave just gave us. And as with the slide that Dave just went over, the next two slides are at a somewhat high level. We're speaking generally here about some commonalities between the various state laws governing consumer privacy rights in order to not to have to dive too deeply into the details of each, which would expose some differences. So right now we're sort of speaking at the 30,000 foot perspective. And of course, we're happy to explore with your particular business the nuances and the details of any specific law, whether that's Colorado or Virginia or the like, and how it might apply to you in the future. But right now, we're just trying to provide a general introduction to the concept. So who is regulated? State privacy laws focus on businesses, or you may have heard the term data controllers. Data controllers is what's often used in Europe with respect to the GDPR, and it's kind of made its way across the pond here. And you can think of businesses as the companies that are actually collecting the personal information directly from consumers. Depending on the specific state law, and this is sort of modeled after California, because as Dave described, California, as with many areas of law, was kind of out in the forefront here. It's got a little bit more of a body of experience behind it, and a lot of companies have kind of adapted their privacy policies and their privacy practices towards California. But depending on the state law at issue, the law may be triggered by a revenue or sales threshold. So a business that sells a certain amount has a certain amount of volume of sales per year. A state law may be triggered by collecting data from a certain number of consumers in the state. So for example, if a business collects data from 25,000 residents of Virginia or something like that, the law would be triggered. And finally, it might be triggered by selling, and selling is in quotes here because it doesn't always mean selling, trading information for money, but can mean trading information for other valuable considerations. So perhaps an exchange of services or an exchange of some other valuable item, the data of state residents. So that's, so the law's focus is on businesses themselves, the folks actually collecting personal information directly from consumers, but they sort of incidentally place requirements on service providers. And as you'll see in the next slide, service providers are often described as contractors or processors. Different terminology is used with slightly different definitions. And for present purposes, we can just lump those together. So, and I'll use the term service providers or processors, but we can assume it essentially means the same thing. A processor or service provider is someone who receives and processes personal data on behalf of a controller for a business purpose. And processing is one of those words that's very broadly defined. It's one of the few words we do know what the meaning is in a lot of states, despite the fact that we don't have the regulations and the sort of detailed administrative information that we would expect with statutes once they've been in place for a while. Processing can mean collecting information on behalf of a controller, using information on behalf of a controller, storing it, disclosing it, analyzing it, deleting it, modifying it, basically any sort of touches, meaningful touches of personal data on behalf of a controller for a business purpose can leave someone in the category of a service provider. That's almost always pursuant to some sort of contract with the business that has specific instructions and requirements for data processing and limits on further sharing of that information. So just to try to summarize that a little bit, I know I just threw a lot at you. A service provider is someone who provides services, but usually through a contract to a business that's actually drawing the data directly from the consumers. And that is the business, and that is processing the personal data on behalf of that business. And that could be defined simply as using the personal data on behalf of that business and for their business purpose. If we could have the next slide. All right, so here I have summarized all three: service providers, contractors, and processors. And service providers are required to assist data controllers in fulfilling their obligations, most predominantly responding to consumer requests. Dave has already touched a little bit on what those consumer requests might be. For example, a request to delete data or to be forgotten or to opt out of the sharing of further information. But it's worth noting that a service provider doesn't have to respond to a request submitted directly by the consumer to them. So for example, if the business that you service is Macy's stores and you get a request directly from a Macy's customer, you don't have to act on that. It has to come through Macy's, and you have to assist the data controller in meeting their legal obligations, but you should not, as a service provider, you are not directly interacting with a consumer themselves. As Dave also mentioned, service providers have obligations to assist in data security and perhaps to engage in data breach notifications. That's a little bit broader than just the state privacy laws. That's sort of a general good practice that we're seeing cropping up in different areas of the law or in different states as well. And there may be additional contractual requirements. Some of the newer statutes that have been passed, most notably Colorado and Virginia, have specific contractual obligations between a service provider and the business, the data controller, which often set out additional confidentiality requirements or data security obligations in handling data. So for example, both in Colorado and Virginia, the business is supposed to inform the service provider whether to delete or return personal data after the provision of services is complete. And that's the type of thing that should be spelled out in the agreement between the service provider excuse me, and the business. And finally, another general duty that a service provider might have under these statutes is to submit to audits by the controller and to share information with the controller in order to help that controller keep compliant with state privacy laws. So just looking at the slide, just a word on the top of the slide here, the section reading sale. I just wanted to note that some state laws, such as California's, place additional obligations on a business that is selling personal data to a third party. And as I've already mentioned, sale can be broadly defined to be more than just selling information for money, but receiving any sort of valuable consideration in return. But these laws do expressly exclude disclosure of information to a processor. So all that's really meant by this top section is that disclosure alone to a processor won't trigger any additional obligations under state privacy laws regarding the sale of data. So
hey, Stacy, can I jump in with a question?
Sure.
Many of the folks here may be in one degree or another involved with complicated relationships with customers and other providers. So if you've got an agency, whether it's in-house or separate, that works with a retailer, for example, to have printed materials produced and distributed to a list of addressees, and the retailer supplies a list of its customers, a house list, and that goes to the agency that in turn is passing it along to someone to do data processing to get it, cleaned up and put it in postal order and so forth. And there's another part of the business or another separate entity who does the production, which would include producing the mail piece physically as well as applying an address to it from the list. Can you identify in that kind of a somewhat complicated connection, a series of connections, who's who and who has what obligations as a result of their role?
I mean, good question, and I'm not sure I have a tremendous more in the way of specifics to give you, Leo. But what I can say is, I guess a couple of points. One is it is possible for a service provider to be both a service provider for some purposes and a business for other purposes. So that's something to sort of keep in mind in the first instance. And in the second instance, I would suspect that under these newly emerging laws, that type of relationship would be kind of dictated by contract and by perhaps some contract reform to make clear. So the laws do provide an avenue by which sort of further disclosures need to be made. So a service provider that requires sharing the information further to kind of fulfill its mission. That is something that is contemplated by these various state laws, and it would be something that should probably be dictated by contract.
So, so I guess the advice would be then that if you are a company who is fulfilling any of these functions or these roles, that you have contracts that have been appropriately examined by folks who know about privacy law to make sure that they provide the correct definitions of who's supposed to do what and who has what obligations and who doesn't have what obligations.
That's right, but I do want to, and I'm sure you're already aware of this, but I do want to, advise that right now all we have for information in terms of some of these statutes is an 8-page statute, the bare minimum itself, and the underlying agencies are in the process of drafting a number of probably hundreds of pages of regulations that are going to spell out and deal with specific examples in more detail. So absolutely, how you just framed it is correct, and you should be looking at contractual arrangements with an eye towards making sure they're privacy compliant. But I do want to also add that within the next year, we're going to see a lot more substantive detail about what those contracts should require, and also some more nuances in terms of multi-role functionality and things like that.
Okay, thank you, Stacy.
You're welcome. Very good question. And so with that, I think if we could move to the next slide, and I believe I will take a drink of water and let Dave tell you all about California here.
Thank you, Stacy. Yes, I have the good fortune to be a California native and admitted to the California bar. So I get all of the fun California issues and questions pointed in my direction. California, I guess Nevada was technically the first state to enact one of these laws, but it's of much narrower scope, and we'll address that down the road. California was the first to have a broadly applicable and sweeping state privacy law, which went into effect in January of 2020, with enforcement of the law having gone into effect in July of 2020. And if you're really interested, the California Attorney General in the last month or so published a 1-year update on his enforcement efforts of the CCPA in an effort to, I think, put businesses on notice of what they're up to there, but also to provide some of the context that has been missing for what their points of emphasis are in terms of enforcement. So the basic structure is similar to the one I outlined at the beginning of the presentation. Under the CCPA, a business, which is defined by statute, determined based on whether you receive the personal information of a certain number of California residents and or trade in the personal information of California residents. But most businesses of medium to larger size are potentially within the scope of the CCPA and are required to provide notice of what personal information is collected, the purpose for which that personal information, purposes for which it's collected, and who that information is shared with. In the third category, it's not a requirement that you identify specific businesses with which you engage and exchange personal information, but rather categories of types of businesses, email marketers, print firms, anyone who social media networks, anyone with whom personal information might get exchanged. And California provides consumers with 3 basic rights and 3 rights that they can inquire about of businesses. And important to note, as Stacy mentioned, when a company is in the position of a service provider, that company does not have a direct obligation to respond to a consumer request if the work that they're doing is solely and exclusively pursuant to a contract with a business that has the direct consumer-facing relationship, the retailer in the example that Leo was giving before. A California consumer has the right to know what personal information a business has in its possession, and that request can take the form of a request to know what categories of information are in the possession of the business, or the specific material, the actual items of information. And there are details in the state regulations about how to manage those requests. But suffice it to say, that can get quite detailed if the consumer's interest is in identifying all specific pieces of personal information in the possession of a business. The California consumer also has the right to request the deletion of personal information in the possession of a business. And again, as I said before, in this context, especially under the California law, there is a tension within the statute that has not been worked out through regulation or litigation to this point, because there are a number of exceptions to the under which a business can deny a deletion request with respect to certain information if that information is necessary either to fulfill a contract, comply with some other law, or to perform the services or provide the goods that the consumer has requested. So you can imagine in a context, if a California consumer asked that you delete their personal information, but it was a retail transaction involving a good, and the business has some obligation to retain records so that in the event of a product recall, they can contact all of the consumers who have purchased that good from them in the past. It's not clear that there's much information, if any, that the retailer would have to delete. But nonetheless, you would have to provide any business in responding to one of these requests at the first level has to validate the request, and there's a process for that I won't get into in detail. And once that's validated, has to respond to the request, and if the response is a denial, has to provide the basis for the denial. So even if there's a good reason to deny a deletion request, there's still going to be a fairly significant process that a business has to go through to provide a sufficiently informative response so that the consumer understands the position of the company. Finally, and most familiarly, and probably the easiest to deal with, a California consumer has the right to opt out of the sale of personal information. The key thing on that point, which is a definitional issue that Stacy brought up earlier, is that sell in California is very broadly defined as the exchange of personal information for consideration in any form. And the general understanding is that, for example, exchanges in a co-op arrangement where the quote-unquote consideration one receives for personal information is other personal information from other third parties, likely would constitute a sale under that definition. So do not sell is broader than do not sell for money, and it's important to bear that in mind. If I could have the next slide, please.
Hey, David, I got a question
Yeah.
just popped in here, if you don't mind. It says,
Please.
when do CCPA notices need to be made, especially as it relates to prospecting direct mail campaigns?
That is a real challenge, and the regulations do provide some, and in this respect, some useful and also beneficial information on that. In the context of an online website, it's clear from the regulations that having a link to a privacy policy as you see most businesses do at the foot of their homepage and other product pages, as provided that link isn't hidden, isn't smaller than other links, is conspicuous enough to be identifiable, that link to a sufficiently detailed privacy policy does provide sufficient notice. The regulations have taken the position that there are times when offline notice may be required both in the context of inside a retail store, but also in print materials. And the scope of that note, what's required for that notice has yet to be fleshed out that I've seen. I think what makes sense to me and what I think is adequate would be to provide notice of the privacy policy via a link or some other reference in the print materials. The key statutory language that has yet to be adequately fleshed out is notice must be provided at or before the time the personal information is collected. It's my view that a notification in a piece of printed matter to see our privacy policy at www.privacypolicy.com would provide adequate notice, but that's a tricky question that remains unresolved at this point.
Okay, thank you, David.
Yeah, and as you can see from the slide, that led nicely into my next point, which I think I've covered in response to the question. Essentially, from a compliance perspective, regardless of how the statute ultimately gets interpreted by the Attorney General's office or by courts in the state or federal courts, providing notice at the earliest opportunity for you to provide notice is the key thing. And so what we've been advising our clients is making a good faith effort so that a privacy-minded consumer could, from the material that's in front of him or her, determine how to figure out what the privacy policy of the business was. And essentially funneling that person to the privacy policy posted on the website in whatever way that needs to happen, whether that's on print matter or in a verbal communication, an oral communication on the phone or online, is the critical step. And here's going back to Leah's first question and what Stacy was talking about, the key difference between service providers and businesses. Under California law, that's a bit better developed than in other states at this point. The key defining characteristic of a service provider for California purposes is that they may only use personal information provided to them by a business for the specific purposes set out in a written agreement. So it's critical to review contracts to make sure that what you are doing with personal information that's provided to you is solely and exclusively item that fits into the categories of services that you've agreed to provide as a service provider. That provides you, both the business and the service provider, the maximum protection that each side understands what the other is and is not able to do with the personal information. And I'm sure some of you have experienced this directly. We have a number of clients who have consulted on this. Both businesses and service providers have been circulating vendor agreement addendums to cover CCPA issues, which can be an effective way to address this in clear terms that both sides understand. There is a significant, if your use of personal information is limited to what's in the contract, then putting that in writing is going to be beneficial to both parties to that contract. Where things get more complicated is if certain personal information is used in a service provider for service provider functions, while other personal information is used internally by that service provider for business purposes, for its own business purposes. And California has been quite clear in the regulations that a single company can be a business and a service provider with respect to different categories or tranches of personal information at one and the same time, and therefore has different obligations that it needs to navigate with respect to both of those kinds of information, which makes things quite puzzling at times to sort out. And may I have the next slide, please?
Hey, David, I got another question here. Really, it was kind of a, not really a question, but a statement. And the caller is saying, true or false, CCPA does not prevent a business from sharing data, but rather just says you must disclose what you do with it and exactly you share it with, who you share it with.
At the outset, that's a pretty accurate statement of the law. Where that becomes less starting out, that was the state where everyone was in. The only exception to that I can think of that's quite clear is once a consumer has made a request to delete certain information, then you have an obligation to review that request, delete information that's not that doesn't fall into one of the categories of exceptions that I referred to, and ensure that you honor that request for the period of time set out in the statute, or until the person re-engages with you in another transaction or another communication to override that request for deletion. Yes, the focal point of the CCPA is that businesses need to notify the world what they're collecting, for what purposes, and who they're sharing it with. I think that's fairly accurate.
Okay. And just to make sure that everybody else knows that if they have any questions, there's a chat box or a question box into which you can ask questions. And that is where I'm getting things that I keep interrupting David with. So thank you, David, again for answering that.
No, not at all. It's a good question and timely asked. I'll go through the California Privacy Rights Act, the new and improved CCPA, a bit more quickly. We're looking at a launch date for this ballot initiative that passed last November through California's referendum process. This will go into effect January of 2023. Key points to think about as you plan for that date: the right to know will have a longer look back period. That is, currently it's a 12 month, you're required to look for information from the prior 12 months as of the date of the request. That period of time will increase in January of 2023. The statute will add a right to correct that I talked about at the beginning. That is, once the consumer identifies what personal information a business has, it can request that be changed to reflect to correct inaccuracies. A new, more protected class of personal information called sensitive personal information is being adopted, and there will be even higher data security requirements relating to that. There was an open question under the CCPA about whether so-called cross-context behavioral advertising was or was not covered. Under the new version, it clearly is covered, and the opt-out request will include that type of personal information exchange. We haven't really talked about remedies, but California so far is the only state that has allowed individual citizens to, after going through a notice and cure process with a business, to file private litigation on their own behalf against businesses. That's going to be, it's still limited to the data breach context, but and so you can't sue in California over any violation, but you can, the scope of the violations that will be subject to litigation will increase somewhat. And last of all, as the bottom of the slide indicates, the enforcement authority is being removed from the Attorney General's office and placed in a entirely new state agency, which is in the process of being created. And so whether that will lead to better or more clearer or more extensive enforcement remains to be seen. Now we can go to the next slide, please, and talk about Virginia, which was the next state to follow California and has adopted a Consumer Data Privacy Act to go into effect in January of 2023. Like California, the definition of personal data is quite broad. The general structure of the law is very similar to the CCPA. It includes a right to know, where you can request copies of the personal information. And that right to know includes what I was just describing, the right to correct, that will be introduced in California at the same time in January of 2023. There is a right to delete, similar to what you see in California, and a right to opt out of targeted advertising, the sale of personal data, and so-called data profiling. Importantly, Virginia made the determination that they would allow enforcement of their statute only by the state attorney general's office. So unlike California, a private citizen may make a complaint under the CDPA, but will not be allowed to file a private lawsuit, which eliminates the even scarier specter of a private class action under the Virginia statute. So look for that statute to begin its life in January of 2023. As I said, the changes are, the differences from California are not tremendous. So if you have in place a good scheme for responding to data requests from California consumers, I don't think there will be a tremendous amount of work to be done to accommodate the Virginia statute. And with that, I will turn things back over to Stacy for the next slide.
Yes, thanks, Dave. Well, unlike Dave's connections to both California and Virginia, I have no connections with Colorado. But on the other hand, I think poor Dave has just done yeoman's work by running us through 2 states. So I'm happy to take a turn here. The Colorado Privacy Act is very recent. It just actually came out earlier this summer. And because it's so recent, the regulations that we've been talking about all along, the more detailed rules put out by state administrators regarding the law, which helped clear up a lot of questions in California, although it also helped generate some questions in California, have not yet issued. So what we know about this law is pretty limited. Again, it just came out essentially a month or 2 ago, and there is a lot of speculation out there at this point. What I can tell you is that the Colorado Privacy Act is fairly similar to the Virginia one that Dave just took us through. So with that, it's sort of a cousin to the California law, and I would say probably a sibling to the Virginia law. So it's very similar. Although, you know, part of the issue is that when you have 50 states and you don't have a federal law in the area, you have slightly different requirements for every state that adopts one of these. So without further ado, I'll just take us through what we do know about the Colorado Privacy Act with its clever and original name, Colorado Privacy Act. And it's a similar structure to what Dave has just told us about in California and Virginia. It provides consumers with certain rights, the rights to opt out of targeted advertising, the sale of personal data, and profiling. Profiling is essentially the automated processing of personal data to try to predict an individual's interests, behaviors, things like that. The right to access, correct, delete, or obtain a portable copy of data. Again, that's all pretty standard, and we've seen it in the other 2 statutes that Dave has discussed. The one that may have the most relevance to service providers is, of course, the right to delete. So if a business is asked to delete data, it may also need to approach service providers about deleting the data that it has shared with a service provider in the past. Something new about the Colorado law is that unlike its predecessors, it requires a business to set up an internal appeal process for denials. So if a business is unable to fulfill a consumer request, it has to give a consumer sort of a mechanism to appeal that denial. Like its predecessors, Colorado has a privacy notice requirement. That is specified as being a privacy notice requirement on the controller, on the data controller, and not the processor. But the data controller should be specifying what types of personal data they are processing. So if they are sharing with service providers, that should be shared in the controller's privacy notice. The controller also has a duty of care, an obligation to take reasonable measures to secure personal data. That is expressly, again, a duty on the controller, but the statute also makes clear that the processor, the data processor, may share responsibility for keeping data secure through their processing activities. And again, that's something that should be explored probably by contract. Colorado sets out an opt-in consent requirement if data of minors is processed or for processing sensitive data. Sensitive data would be data, for example, that reveals racial or ethnic origin or some sort of health condition, genetic information, things like that. Colorado also sets out a requirement that a controller has to conduct a data protection assessment for processing activities that present a heightened risk of harm to consumers, generally for advertising, selling data, or processing sensitive data. Again, that sensitive data is a category that Colorado is particularly concerned about. And again, that obligation to do a data protection assessment is one on the controller. The controller is supposed to weigh benefits and risks of doing the processing and consider mitigation measures for processing activities that might present that heightened risk of harm. But if they, of course, determine that mitigation measures need to be taken, that is something that might float down to the processor themselves. And the final thing to note is, like Virginia, there is no private right of action here. You can't see individual plaintiffs bringing a claim under this law. But unlike Virginia, Colorado has opened up enforcement to not simply the state attorney general's office, but local district attorney offices. So you have additional enforcers, and of course, while it remains to be seen, more enforcers may mean more enforcement actions, but that is something that we will have to see down the line. And the way that that violations are brought is similar to Virginia and to California in that regard. There's a notice of violation, and at least for the first 2 years of the statute, there's an opportunity to cure any violation, to essentially fix it. So before any charges may be brought. So with that, I'd ask for the next slide.
Hey, Stacy, I got a couple of questions here, if I can interrupt you for a second.
Right, I will
the
say
easiest
that I don't
one
know the
first.
answers, but yeah, go ahead.
Fair enough. The first one is, does Illinois have a similar privacy law in place?
I do not believe
or in the works?
So. It may be in the works, but I do not believe I don't believe they have one in place, and I'll ask Dave to just correct me on that if I'm wrong.
No, that to my knowledge, yes. I believe Illinois has contemplated a bill, but it hasn't made its way through the legislature at this point.
Okay. And then the second question is, what besides having a contract in place can a mailer do to protect itself?
Well, it's a good question. It's a pretty broad question. I would say the most important thing, I think, and not just simply for purposes of this privacy law, but is to make sure, but sort of just the general way our laws are trending, is to make sure that it has robust sort of data security protocols in place. That it is, anything that is arguably personal information, that it is keeping tabs on that, that it has confidentiality agreements with any of its, sub vendors that it needs to use for anything, sub processors. That's really, I think, the mechanism through which poor data security practices is really, I think, the mechanism through which we're going to see most people most companies getting in trouble in the near future.
So if you can show you're doing a good job or trying to do your best, that may count.
Right, and so for example, in California, the way the way that individuals are allowed to bring claims under the statute is if data gets lost. So buttoning up your procedures, making sure that data is not lost, is sort of the best way to protect yourself, both in terms of showing that you're taking reasonable precautions with the care of personal data, and potentially preventing any leaks in the first place.
Okay, and then I've got one more popped up here as we were talking. This is sort of a situational question. What if you're located in New York, or you're doing direct mail work for a company headquartered in California? Does the service provider in New York have to comply with California privacy laws, or does the privacy law only apply when the mailing list is going to California residents? Is that if a portion is in both states, how does that work? The privacy laws apply for both states in that case, or how do these laws apply if there's multi-state activity, I guess?
Yeah, another good question. And so that's really, in some ways, going to depend on the state. And I understand that the hypo is in California. But I would say that if it is work for a business that is located in California, the business in California is likely going to ask you to comply with these requirements, not only for the portion of mailing lists that are going to California consumers, but also to those that might be going to Nevada, Illinois, et cetera.
Okay. All right. Thanks. I'll let you get back to your slides here. Thank you.
Oh, no problem. It is, as Dave I think has mentioned earlier, it's nice. It's kind of nice to have the interruption, and to know what people are thinking. But with that, I think we're now on leaving Las Vegas, and I will turn it over to Dave to take us out of Las Vegas.
Thanks, Stacey. Just in response to the last question, which is an excellent question. Under the California statute purports to apply to any business, essentially with gross revenue of 25 million, I believe, or more, regardless of where that revenue is generated, and to the personal information of any California consumer. And the state has taken a very broad view on how far outside California it can reach to require compliance. I hope and expect at some point the scope of the application of the statute is going to be challenged in court by someone, but that has not happened yet. So I think it is generally safer and probably makes sense from a risk-reward perspective to assume that if you meet the thresholds for the California statute, or if a business that you work with does, that you're compliant, that doing the best you can to comply is probably the safest approach and probably also the most economically smart approach. I will speak only briefly about Las Vegas before we can leave it behind, simply because Nevada, the scope of the Nevada statute is much narrower than these others that we've been talking about. The key point is that to be under the jurisdiction of the Nevada statute requires the exchange of what they call covered information, which is their version of personal information for monetary consideration, specifically by the operator of a website, specifically, or for an agent of that operator. And so, unless you are in the business truly of selling or purchasing for money personal information, the Nevada statute is not one that you're likely going to need to be concerned with. If you are involved in those kinds of transactions, then you're going to want to look at the relatively narrow scope of that statute, and it will require, in essence, an online notice, much narrower but similar in the concept to the California statute. And can we have the next slide, please? And we can leave the world of state privacy law, at least for a short while.
Yeah, I'm mindful of the time, and we're sort of about to switch topics entirely. So I will just do a kind of a very brief rundown of this slide, which I think is our second to last, and then we can leave some time for any additional questions at the end. And the point of this sort of kind of off-topic slide, so to speak, is just as sort of a reminder that there are other issues out there other than privacy that affect mailing and consumer rights to not be bothered, so to speak. So one of the older statutes, I think it's about 20 years old now, maybe a little less, is the Deceptive Mail Prevention and Enforcement Act. I suspect many of you may know that law equally or as well or better than I do. But just sort of as a reminder that is a federal law that's out there that restricts mailings with misleading references to the U.S. government. So, putting mailings with pretend seals or insignias on them. It imposes content requirements for sweepstakes, those kind of, I don't want to use the term lottery because that's a highly charged term, but the kind of contests where winners are determined by chance, content requirements for skill contests where winners are determined by skill, and fake checks. There's specific detailed requirements for what needs to be in place to make any of those sort of contests mailable. and there's a requirement that promoters, the folks who originate and mail or cause to be mailed a contest, have to include a statement that the individual has the right to opt out of future mailings, establish a mechanism for them to do so, and honor any do not mail requests for 5 years. So that's sort of the federal requirement. And then, of course, many states have laws specifically governing sweepstakes, prize, contest mailings that may add on to those requirements. So there may be additional disclosure requirements, there may be record keeping obligations, or so for example, the requirement that past winners of any prizes be published. So with that, again, I just wanted to kind of touch upon not privacy issues per se, but a right of, there are other laws out there that do touch upon a consumer's right to be let alone, so to speak, and that is one of them. So with that, I think we have one slide left, maybe. Let's see. Oh yes. All right, Dave, if you want to close this up for us.
Yep, and I won't dwell on this because I do want to leave more time for questions that might be of more direct relevance to the audience. But there are reasons to think that, there are many reasons to think a federal privacy law is a good idea. If we had a single preemptive law that announced a clear standard that was applicable across all 50 states, it would be of great value both to consumers and to businesses and their service providers, providing a clear and an even playing field for everyone and a clear set of expectations. This has been an area of interest in both houses of Congress on both sides of the aisle. There are some sticking points that have stopped. Aside from the general fact that Congress is having a hard time getting things done, period. So I'm not sure you can look at this as from a glass half empty or half full perspective. Congress has had limited bandwidth on issues outside of the immediate concerns of COVID response and the economic turmoil that has caused. But there are folks on both sides of the aisle that are interested in privacy issues. It's not necessarily an ideological, an area where there's an ideological divide. And we are working with some of our clients and some other retailer and business groups to urge Congress to take action to create a single uniform standard, because if the other states follow in the footsteps of the 4 or 5 that have gone so far, the array of obligations that businesses and service providers will be facing will be vast and potentially contradictory and just a huge challenge, and much like the tax challenge that I'm sure many of you are familiar with. So I'll leave it at that for now, and I'm happy to address any questions along those lines offline by email. But if you have any immediate questions about the presentation, we're happy to take a couple minutes to answer them.
As it turns out, right now there aren't any questions in the queue. But I've seen a few go by before, of course. You made an interesting point earlier about how this is similar to the tax law situation because you've got different states doing different things. And is this something which could end up going through the federal courts to all the way to the top and have a court decide what is a legitimate action by a state? So, but at the same time, what is not a legitimate action by a state in these privacy laws?
And the one thing about the tax context that was, whatever you think of the Wayfair decision, that has been useful is that the Supreme Court found a Commerce Clause issue in these state tax jurisdiction questions about which states can reach out to what businesses and require them to comply with their sales and use tax obligations or other tax requirements. It's not clear to me that there's a similar constitutional issue in play. As I said, I do think my personal view is that the state statutes that for like California's that purport to reach outside of California to affect any business throughout the country that happens to collect information about California citizens is subject to a challenge, a jurisdictional challenge of some sort. And so it would take a business that was willing to dig in and fight on that issue for whatever reason, or a trade organization to create that challenge. And I haven't seen any appetite for that so far, but it is possible. It's what is clear is that that Congress could adopt a preemptive law that said this is how privacy issues are going to be handled nationwide, and the FTC or whatever agency is going to be responsible for administering and enforcing that law. And I think that would be immeasurably better than the piecemeal approach that we're starting to see state by state.
Right, but of course, don't hold your breath for that to happen, as you said. Well, I think we're approaching to the time to send everybody back home, and we appreciate the fact that we had callers today asking so many questions, and good questions. If anybody does have any more questions, of course, they can send them to David or Stacy at the email addresses on the screen, or send something to us, and we'll pass it along if you prefer. And in the meantime, we want to thank Stacy and David for being our presenters today, for giving us some great information and answering some tough questions. And I want to thank Michelle for being in the background, making sure things are working, has the lights on and whatnot. And thank all of you for calling in today. So until we have a chance to talk to you again on our next webinar next month, take care, stay safe. And with that, bye.
Thanks all, appreciate it.
Thank you.
Thank you, Stacy. Thank you, David.